Everyone, this is the staff attorney. You do not have to unmute or go on video. I just want to let you know Judge Krause is momentarily delayed and has asked me to have you all stand by, and she hopes to be on soon. By way of an update, Judge Krause expects to be on by 3:10 p.m.
Thank you, Mr. Freehoff.
Hello. Judge Krause, please forgive my being late and the fact that I'm in my car. It has been a bit of a crazy afternoon, and I'm currently at the hospital with my sister. So, tell me, it's also because I'm on my phone, I can't see everyone who is a party. Right now, I'm only seeing Derek Bauer. So if I could get a quick announcement of who all is here and whether or not we have a court reporter.
Judge Jake Evans, on behalf of the petitioner, Georgia Bioscience Research, Inc., I do not believe we have a court reporter.
Okay, thank you. Hi, Mr. Evans. How you doing?
Doing well, thank you.
Okay, and who else do we have?
And hi, Judge Krause. This is Derek Bauer for FFD.
Okay. Do we have anybody else?
Judge Krause, hello. This is Jeff Zachman for Nature's Georgia.
Okay. And Nature's Georgia, you are one of the, okay, because again, I apologize. Sure. FFD and Nature's Georgia, and there are two others that were provisional licensees, but the provisional licenses have never been issued for the Class 2 licenses, correct, sir?
Presumptive Class 2 winners.
Right, thank you. The presumptive Class 2 licensees. That's a better way to put it. Thank you, sir. Anybody else?
Good afternoon, Your Honor. This is Vincent Russo on behalf of TRO Georgia.
Okay, thank you.
I think I'm the last one, Your Honor. Joe Sternberg on behalf of Truvon and Remedy.
Okay. So let me first Am I correct, Mr. Evans, that this is a new matter that was filed of recent for the purposes of securing a TRO to prevent the entry or to prevent the meeting that's scheduled to go forward today at 4 p.m. from going forward? Is that correct?
So this is actually, we filed it in our current matter, which is up on appeal, and the court has the ability and maintains jurisdiction over ancillary matters. I've got a number of case sites I can read into the court, and I'm actually at the courthouse. So if you hear voices, that may be people in the hallway. So I apologize for that. I'm housed up.
Yeah, the circumstances being what they are, I understand that everybody's probably in odd places, including myself. But that's not actually why I asked the question. Why I asked the question is, if I'm just going to mention this and then we'll put it aside and we'll move on to the substance of what you're presenting. But especially given that this was in a case that was still pending before me and that it relates to Class 2 licenses, if you made an effort to contact my staff, you need to provide me with that information, because I don't think that you should have gone to the presiding judge. You should have brought it directly to me before seeking out the presiding judge, who correctly brought it to my attention and said, this is your case. Why would I be dealing with this? And we tend to be pretty responsive when it's brought to our attention. So if it was brought to our attention and we did not respond, I understand you were on a tight time schedule, and I'm not going to fault you for it, but I will just point out that there are some that would perceive that as an effort to go around a judge who'd already made some adverse rulings to your party, and I don't think that's what you did, but I think you should avoid the appearance of it looking that way. And that's all I'm going to say about that. We're going to move on from there and focus our attention on what I understand to be the case, Mr. Evans, is that your client, Georgia Bioscience, is seeking a TRO to prevent a meeting of the Georgia Medical Cannabis Commission that is scheduled to take place by phone today at 4 p.m., at which the commission has indicated that it intends to consider provisionally granting the Class 2 licenses, the winners of which were identified previously, but those licenses have never been provisionally granted, which is why the case was procedurally distinct from the Class 1 licenses, which I understand were provisionally granted prior to the entry of any restraint. So I think that's what I understand. And your position is that the Georgia Medical Cannabis Commission is not authorized to do that because supersedious prevents that action. And so if you want to take it from there, Mr. Evans, and tell me what your client's position is.
And that's exactly right, Judge. And we really appreciate you accommodating us today. And in no way was us going to the presiding judge and it trying to backdoor around. And we apologize for that at the outset. We appreciate the court making that statement. You've got the gist of it. You know, we're running up against somewhat of a tight crunch. We're at 3:07. I think the meeting's at 4 p.m. But you're exactly right. As the court is well aware, and we briefed significantly, and I think you know this as well as anyone, Judge Krause, OCGA 5419, OCGA 5317, both of which make very clear that when you file petitions under OCGA 541 or the newly adopted statute, that operates as a supersedious of the judgment until the underlying case is concluded. That's 5419, and then 5317 expressly provides that the filing of the petition under the chapter shall operate as a supersedious and shall suspend but not vacate the final judgment of the lower adjudicatory. Your Honor, as well, in your November 15th order in one of the cases before you, which was the Aspire case, you made very clear that the motion to dismiss did not preclude the supersedious. The supersedious did maintain and go on. So because of that, we were absolutely shocked to see that the issuance of a provisional license today at 4 would be going forward. I didn't find out about it until about 6:30 p.m. and we had to kind of jump to action to try to figure out exactly what to do. As the court knows, OCJ 91165 makes clear that Your Honor has the authority to issue a temporary restraining order that would preclude and enjoin the meeting at 4 p.m. from going forward, that would enjoin the issuance of any of these licenses. This is the exact instance where we maintain the status quo. I don't know how what happened, but undoubtedly at a minimum, Judge, my client has an opportunity to figure out why it happened, this would create very significant irreparable harm. The Court of Appeals made a decision that suggested that the fact that the Class 1s had been issued had a legal impact on their ability to seek the relief through the bid protest. If the licenses are issued here, I presume the respondents will make the same argument that our ability is greatly precluded in seeking the relief that my client is seeking and also some other parties are seeking as well. So given the severity, given how clear the law is on this issue, maybe there's an explanation that I'm completely and totally unaware of. And if that explanation does exist, at a minimum, we have to maintain the status quo, allow for briefing on this issue to figure out what exactly is going on, because I think the law is very clear, and we have a very short period to do that. We have a proposed order that we can submit. The TRO is supported by an affidavit of Mr. Kugel, and the standard under 9/11/65 is we have to show immediate and irreparable injury, loss, or damage or result. Allowing an issuance of a provisional license in this instance would undoubtedly cause irreparable injury. There have been significant efforts both in getting the licenses and litigating this case, as your Honor is very well aware, that we have done, and allowing it at this point to go forward would be very significant. The last point I'll make, Judge, is that I don't know if granting a provisional license is even allowed. If you look at the HOPE Act, and we went through the HOPE Act in totality to figure out what a quote unquote provisional license is, the word provisional is not mentioned. So I think
isn't this the larger issue though that I think everybody has struggled with, including the legislature, is that this is that weird intersection between the HOPE Act and the traditional state licensing procedures that do allow for, and routinely, where a provisional license can be, granted, and then the parties have whatever review rights follow from that. Is that not correct?
Well, the HOPE Act is a statute that was created that guides this framework, and it's not mentioned. I mean, at a minimum, we have to maintain the status quo given the severe repercussions of both what respondents have argued. The Court of Appeals had said that this could potentially moot any relief that we're seeking to work all this out, brief the issue, figure out what's going on. And so therefore, given the drastic potential implication of what could happen here in 48 minutes, the status quo needs to be maintained. We are open, Judge, to setting a preliminary hearing on an injunction motion in 30 days, 20 days, but to give all the parties enough time to work through what's going on. But what I don't want to happen is you can't unring the bell. I mean, we let the horse out of the barn here. It's very hard to get it back in, and it could be binary if the suggestion in the Court of Appeals argument is right, that if they're issued, our cases are completely and totally moot. So okay. This is a very—
Mr. Evans, forgive me for interrupting you, but I have one question for you. I think you've demonstrated from your perspective what you believe the imminent harm is that must be restrained. I'm clear in understanding that in terms of your describing it within the context of what the appellate ruling was relative to the fact that Class 1 provisional licenses had been issued and its different procedural posture. But one question I do have for you, and please forgive me because, again, I am in my car and not in front of a computer. I would have normally looked this up. But there were originally 5 cases that I've dealt with, and Aspire is no longer pending. There were the 4 remaining ones. 2 of them are still pending and are scheduled for a final hearing in December. And my recollection is that Georgia Bioscience is not one of them, and that their certiorari action was dismissed because a writ was not issued. Am I remembering that correctly, or is it a different party? And here's why I ask. Because what does the procedural posture of Georgia Bioscience, if I am correctly remembering that matter has been dismissed from the trial court, even if you have gone up on appeal, does it change whether or not you have standing to even challenge what the Georgia Medical Cannabis Commission is going to attempt to undertake at 4 p.m.?
Thank you for that question. So the short answer is no. The judge granted the motion to dismiss as to Georgia Biosciences. We filed an application for discretionary review, which is before the Court of Appeals and being considered. And Georgia case law makes clear that when you take up a appeal, it does not deprive the trial court of jurisdiction as to matters in the same case not affecting the underlying judgment. Trial courts, like Your Honor, absolutely maintain jurisdiction to rule on ancillary matters, especially matters which maintain the status quo pending the resolution of the appeal. So the court and Your Honor absolutely has the jurisdiction to grant a TRO to maintain the status quo. And it may be some of the other, I'm not going to speak on their behalf, but the other two class 2s that are pending for you, they may be filing and seeking injunctive relief. This happened. We found out yesterday at it was filed at 3, or the notice went out at 3:58 p.m. The meeting's at 4 p.m. So it was very quick to try to get before someone like Your Honor. We appreciate that accommodation, but we strongly believe, given the significance of what's at play, given the amount of effort, time, resources that have went into litigating this case, which Your Honor is very well aware of, that we need a TRO to maintain the status quo, to not allow these licenses to be issued, because that could and would potentially cause irreparable harm, to work all this out, talk about it, figure it out, and then at a later date, whenever all the opportunities have proper notice to work through the issues, a court, maybe Your Honor, will consider a preliminary injunction, which can address this more than just 30 days out.
Okay. Thank you, Mr. Evans. Who am I going to hear from on behalf of either the commission or the winning licensees?
Good afternoon, Your Honor. This is Derek Bauer. With your permission, I'll speak first on behalf of the presumptive Class 2 licensees that are defendants.
Okay.
I don't believe the commission is represented in this proceeding.
Okay.
And you may have seen or may not have seen that the correspondence from the Assistant Attorney General that represents the commission, Jeff Stump, that he would not appear at this hearing on behalf of the commission because the statutory notice wasn't provided to the AG's office of an attempt to get an injunction against the state. I think I can clear up a lot of this. And the reason why I corrected your language at the outset of the hearing about presumptive versus provisional is because nothing that the commission is intending to do at 4 o'clock alters the status quo, including the rights of Gabry, who's the petitioner here, to continue pursuing its appeal of your court's dismissal of its cert petition seeking to review the denial of its protest below. And let me explain why. The Class 1 licenses that were issued last year, moments before some of the protesters, including Gabry, obtained injunctions from various superior courts around the state. That was the APA issue, the court will recall. Those licenses were not provisional. Those are final contracts and final licenses that were issued to the Class 1s. The protests that are pending before you, the ones that you referenced that are still remaining to be heard on December 21st, that's ACC and Symphony. The court's correct that Gabry and another Pure Peach were dismissed.
Pure Peach, right.
Yes.
Thank you.
And I know dismissed with prejudice and motions for reconsideration denied by the court. Those are also protests over the commission's notice of intent now 30 months ago to issue final contracts to the presumptive Class 2 licensees, the defendants in front of you today. What's happening at 4 o'clock is the commission exercising its lawful authority to issue provisional contracts. And when Mr. Evans says, I don't know if a provisional license is even allowed, well, we can answer that question under clear legal authority that's provided in the HOPE Act and the rules of the procurement that Gabry, through its counsel, has accepted and waived any right to challenge years ago. So here's the state of affairs. If I share my screen, are you able to even see it?
I should be, but if I can't see your screen, I'll tell you immediately, Mr. Bauer.
Right, I'm going to try. So I want to start by showing you where the authority comes from. What the commission is doing at 4 o'clock is issuing provisional, i.e. temporary contracts to the presumptive winners that are subject to the outcome of the protests that are still pending, including Gabry's effort to review your orders in the Court of Appeals and ACC and Symphony that are going to be heard by you on the merits on December 21st. So what the commission is saying today at 4 o'clock is, we recognize there are continuing protests, but these protests have delayed getting medicine by the 4 most qualified applicants for Class 2 so long that we are exercising our statutory and regulatory authority to issue temporary provisional licenses so that we can stop the delay while the protests continue. And as I'm going to show you, the contract that the commission is set to approve at 4 o'clock today is directly contingent on the outcome of the protests. So if any protester, including Gabry, succeeds in a protest and succeeds in getting an order that says that the full final contracts should not issue to any of these Class 2 presumptive licensees, the provisional license and contracts terminate automatically by operation of law. So there is no deprivation of the status quo based on what the commission is doing at 4 o'clock, and there is no injury. There is no harm to Gabry or any of the other protesters at all, because their protests continue. Yes.
Forgive me for interrupting you, but let me focus your attention on the specific point that Mr. Evans was trying to draw the court's attention to, right? Which is this idea that the Court of Appeals ruling, as I understand it, I think he's correct in saying that the Class 1 licenses, the unsuccessful Class 1 licensee challenge was moot, essentially, under APA, because those licenses had already been issued. And I think I understand Mr. Evans' point to be that if the court allows the issuance of these provisional licenses, that will place the unsuccessful Class 2 applicants in the same position that the Class 1 applicants were in, relative to their efforts to seek substantive review either under APA or under the certiorari review.
Thank you, Your Honor. It doesn't, and I'll show you why. And I'm just going to skip to the end of the analysis, which is to show you the contract language so that you can see that the provisional contract that the commission wants to issue today or award today expressly preserves all of those rights of the protesters and is expressly conditioned on their ability to continue those challenges. And there's a very different scenario at play. This is not, the commission is not issuing final contracts at all. It's issuing temporary contracts, whereas what the Class 1s got before any protester secured an injunction were final contracts. And that's what the Court of Appeals said. We can't undo that because you've sought your injunction too late. That's not what's happening here. And let me show you, and I'll move backwards from what the contract says to where the authority for it comes from. So I'll start with the contract. Are you able to see my screen, Your Honor?
So far, so good. Yes, sir. It's really tiny, but I can see it.
I'm going to try to zoom in.
Actually, I am able to make it larger as well, so I think I can see it okay. Go ahead.
All right. Well, I'm just going to show you the top of it here that's so you understand. It says provisional contract for Class 2 production license. This provisional contract is entered, and then it's blank because this is just a proposed contract that the commission is due to enter today. When the key language here is in the last paragraph of the contract that says additional conditions for termination of contract. And I'd like to read it to you if I may, Your Honor. Go ahead. It says the licensee, that would be these Class 2 licensees in front of you.
So for example, FFD or, whoever, right? Nature's Georgia, insert that name there. Is that correct?
Correct, Your Honor.
Okay. Go ahead.
So I'll just use my client FFD, if I may. FFD agrees that the contract shall automatically terminate if 1, a court of competent jurisdiction enters a final decision or final order that A, the contract is void, or B, after the full and final conclusion of any pending post-award protest of the commission's previously issued notice of intent to award contracts for Class 2 production licenses pursuant to the RFP. That's what's pending now in front of you. So if any court decides after the full and final conclusion of any pending post-award protests that after those protests are concluded, if a court of competent jurisdiction has held that FFD is not entitled to receive a contract for a Class 2 production license pursuant to the RFP, which is what the protesters are protesting, and 2, all appeals of such decision or order have either affirmed the decision or have expired or otherwise terminated. If such termination event occurs, FFD agrees that such termination renders the Class II production license as void, and that such termination shall not be deemed a breach of the contract by the commission, the state, any of its people. And further, FFD agree and acknowledge that in the event of such termination, none of the commission, the state, or anyone else can be sued, shall be liable to FFD for any damages arising from the termination of the provisional contract. So this paragraph expressly preserves the protests and basically says presumptive Class II licensees, if you want to go at risk that one of these protests may succeed, then we're authorizing you to do that. But it's at your peril.
Okay.
And key is it's
Bauer?
not. Yep. Sorry.
Sorry to interrupt. So let's say that that language satisfies me. I think the second thing that you were going to show me, though, in terms of the intent of that contract and that it is intended to be provisional, the second thing you were going to direct me to was what you believe gives the commission the authority to enter into such a provisionally limited contract.
Yes. If I may share my screen again.
Go ahead. So far, it's working.
All right. Are you still with me, Your Honor?
Yes, sir, I am.
All right. What we're looking at is OCGA 16-12-210, titled Implementation. This is in, if you can see here, the Access to Medical Cannabis article of Chapter 12, which is the article that created the commission and gives, as you see here, Part 2, role of the commission, describes its authority. Section A of this code section says the commission shall have the following powers, duties, and responsibilities to implement the provisions of this part. And that includes at subsection A3, the power and authority to establish procedures for granting licenses. So let's look, if we may, I'm gonna have to stop sharing and then share again. We're gonna look at the procedures that the commission—
the bid procedures that were adopted, that everybody agreed to, and that y'all's position is that the challenging companies have not objected to those provisions being the applicable provisions, correct? And waive their right to object.
That's correct. I mean, everybody was operating under the same rules, which I will show you in the application, and had an opportunity pre-award before the commission went to all the trouble of reviewing and analyzing and scoring applicants, had the opportunity to say, we don't like these rules and we think something needs to be changed. One of the Class 1 applicants availed themselves of that pre-award protest right, and actually secured a change to the rules as a result. But this particular provision that I'm about to show you was never challenged. And this comes from, you still with me, Your Honor?
Yes, sir.
All right, so this is attachment A to the application instructions for the Class 2 low THC oil production license. So this was what was applicable to the Class 2 applicants, which include all of the parties in front of you. In paragraph 13, entitled Selection and Award, it's just this first sentence, one sentence, but it's very clear. And what it says is the primary intent of this application is to identify 4 sources to provide all of the needed goods and or services for Class 2 low THC oil production. In other words, this application is to get us the 4 Class 2 winners, the highest scoring winners. And then there's a semicolon and it says, however, GMCC reserves the right to make provisional awards at its discretion. What the GMC was telling everyone was, while we're always looking for the 4, and our intent is to have 4 that are going to do this, we have the authority and discretion to issue provisional awards anytime we want, if we feel like we need to implement and establish the provisions of the HOPE Act. So they have the authority to do it. There's no question about it. And I don't even think you need to get that far, though, to dismiss this particular request for injunctive relief, because there is no injury. So I don't even think the court can get into an analysis of the merits when, by definition, the contract says this all goes away if any protester succeeds on their protest. So there's no injury at all, much less an irreparable injury. But there are other problems here. As Mr. Evans said, he filed this case this motion into a pending case that the court already dismissed with prejudice. but that case was before you under the posture of a certiorari review. And 9/11/65, the Temporary and Emergency Injunction Act, does not apply to certiorari proceedings at all. And you've already addressed this in the context of the motion for discovery that you'll recall Mr. Evans' client Aspire filed in advance of the hearing, saying, well, we think the Civil Practice Act entitles us to discovery. This is a civil action. You said, no, this is a cert provision, the Civil Practice Cert procedure. The Civil Practice Act doesn't apply. And that's the same here. The Cert Act gives the court very limited authority on what it can do and limits the court's ability to review the actions below to a certain standard of proof. What you will not find under the Cert Act is authority to enter emergency, interlocutory, injunctive relief, and certainly not an injunction against a state agency. So I don't think there is standing under the plain terms of the posture through the Cert Act that is before you for this to happen. That's number one. So I don't think the court has the authority to do what Mr. Evans is asking, Gabry is asking the court to do. Number two, the court has already ruled that the old the old Cert Act applies to this action. You ruled on that when you dismissed Gabry's petition, because there was a dispute about whether the amended act or the Legacy Act applies. Under the Legacy Act, as soon as you dismissed this case with prejudice, the supersedious went away. And there is no supersedious in Gabry's action that binds the commission in any way, shape, or form. So that's just yet another reason, and that's the only grounds that was presented in Gabry's petition that I read for their request for injunctive relief. And the supersedious is gone, as this court has already ruled in the law of the case in this matter. I've shown you the clear authority, and I've explained to you, I hope, with clarity, why there's no injury here. But there's no prejudice whatsoever to Gabry's rights. They have asked the Court of Appeals for a discretionary review of your order of dismissal. If in the unlikely scenario, the Court of Appeals reviews it, and in even the more unlikely scenario, they reverse it, and upon review on remand to you or back to OSA for in Judge Howells for further proceedings, their protest is preserved. And nothing happens if the commission issues the provisional license that it wishes to issue this afternoon. So the status quo would be upended by your injunction, not the other way around. I want to leave a few minutes for anybody else on the Class 2 side to make comments in addition to mine. So unless the court has additional questions for me, I'd like to rest.
No, thank you, Mr. Bauer. I appreciate that. Anyone else wish to speak on behalf of the licensee, the Class 2 presumptive licensees?
Your Honor, this is Jeff Zachman. I'll adopt everything Mr. Bauer said and very briefly say, even if Rule 65, 9/11/65 applied to this proceeding and it is not, Gabry would have to show likelihood of success on the merits at trial. Your Honors have already addressed that question by dismissing Gabry's certiorari petition. They have no likelihood of success on the merits at trial because they cannot assert a certiorari action. On that ground alone, you can deny the motion for TRO in addition to all the grounds Mr. Bauer set forth.
Thank you, Mr. Zachman. Anyone else?
Your Honor,
go ahead, Vince.
This is Vincent Russo. I'll be quick, Your Honor. On the issue of the supersedious, the supersedious, it's a supersedious of the judgment below. Supersedious doesn't restrain all agency actions that can be taken. So to the extent that there even is a supersedious in place, the issue before you today regarding provisional awards is not something that would be subject to the supersedious. Final award may be subject to a supersedious, but because that's the judgment below, but not a provisional award.
Thank you, Mr. Russo.
And
last but not least,
Chip Collins, and I couldn't say it any better than my colleagues have, so I will adopt all of their arguments on behalf of Truvana. Okay, thank you, sir. Mr. Evans, it is your motion, sir, so you get the last word.
All right, thank you, Judge. The law is very, very clear on this issue, Judge. And this is, I'm going to cite the Bank South case, which is 200 Georgia App 489, which says that under supersedious during its pendency, it prevents any steps to enforce or carry into effect the judgment such as issuing an execution based thereon. That's exactly what the respondents are trying to do here. And I have never seen the contract. My clients have never seen that contract. We have no idea where the contract came from. I assume someone drafted it and gave it to the respondents in the case. But the reality is that the only language they cite that will eviscerate, and I mean eviscerate, supersedious, which is backed by centuries of Georgia jurisprudence, is a language in a piece of document somewhere that says that they have, if you read what Mr. Bauer put before the court, that they can give 4 of these licenses. However, they can give provisional licenses. That can mean just about anything. To me, that means if you read the 2 sentences in tandem, that they don't have to give it to just the 4. They can give it to a provisional license somewhere else. But what it does not say is we are going to eviscerate a centuries-old supersedious effect of decisions that are made at the administrative level that allow procurement licenses to be issued despite pending lawsuits challenging the underlying bid protest. That's what it does not say. There was no authority that in any way said that what Your Honor has found with the supersedious effect, what OCGA 5419 has said, what OCGA 531 has said, what OCGA 5317 has said, what the Bank South case has said, nothing said the supersedious does not apply here. We heard a lot, and Mr. Bauer's a friend of mine. I like him. But there is no way that him saying, oh, this isn't going to in any way prejudice the clients, my clients, the defendants in this case, that is not sufficient. The Court of Appeals made very clear that in the class 1s, the fact that the licenses were issued because we couldn't move fast enough, because these folks are noticing meetings at 3:58 for a subsequent meeting at 4 p.m., that we couldn't move fast enough to get an injunction, that their underlying relief was moot. There is no doubt that there is a possibility of that argument being made here. My clients have spent significant resources applying, going through protocols, many protocols, to protect their legal interests in pursuing this case. We have never seen the license. The authority that would eviscerate underlying supersedious doesn't say what the respondents say that it's going to say. We have to be very, very careful in maintaining the status quo until many of the arguments that I've heard for the first time, that my clients are going to have heard for the first time, are vetted out. As far as the likelihood, the Civil Practice Act applies in all instances in which it is expressly said that it doesn't apply. Injunctions do apply in this instance. There is no authority that says that the court doesn't have the ability to enter an order maintaining the status quo, while that it should happen. This is very serious matter. This is a very consequential result. Nobody is harmed. And in fact, the process is undoubtedly secured. The integrity, my clients are challenging the underlying procurement process, which was not properly done. What will contribute to the distrust is allowing folks at 3:58 to notice a meeting, to issue licenses that we have litigated before this court many, many times, and those just to be issued without anyone being able to vet the underlying law, the implications that's before the court. So we're running now. We've got 22 minutes left. I would implore the court in this instance that we have a situation where quote unquote provisional licenses under a contract that none of my clients have ever seen, with no legal authority that suggests that it does not affect the legal rights of my clients. In fact, the only legal authority that I've seen is a Court of Appeals decision that says that it could, and a document that mentions generally a opportunity to issue a provisional license whenever the first sentence says we can issue 4, or however, you can also issue provisional. that in no way is sufficient to eviscerate centuries-old jurisprudence which says that when you file under this petition, which is exactly what we did, it has supersedious effect, which prevents any steps to enforce or carry into effect the judgment. We are okay with the court setting an injunction hearing in 30 days and setting a briefing schedule on this. But what we are not okay with is allowing all of the work, the resources that have went into preserving these rights to potentially be eviscerated by an 11th hour, 24-hour meeting being called and set with no one having an opportunity to pursue or evaluate the implications of that. So this court has the discretion to enter injunctions whenever there is an appeal on ancillary matters, as long as it doesn't affect the underlying judgment. This doesn't affect the judgment. OCGA 956 says that this court can issue a TRO, and we don't have to show likelihood of success on the merits for a TRO. The statutory language is clear. This is not a preliminary injunction. What we have to show, the law is clear, is immediate, irreparable injury, loss, or damage, or a result. Here, it's clear that this is irreparable. This is significant. The defendants or respondents in this case will not be prejudiced by being forced to wait and litigate the issues that they are so confident about, and allowing a court like Your Honor to hear it, consider it, and make the right determination and fair notice and fair opportunity to be heard. We are merely asking for maintaining the status quo so everyone can see all that's happened, to brief it, evaluate it, and see if what the respondents say is true. I think the law is extremely clear on this issue, Judge. These actions operate as supersedious. We can cite to 20 cases if I haven't been operating in a very, very extremely limited amount of time to show that when you file them, any action cannot be taken and it is undoubtedly prevented. And there has been no legal authority that says that that is not the case here. A TRO is proper. This is the exact instance in which it will happen. We have 19 minutes, so we will send the court the order immediately. We are open to Your Honor setting a briefing schedule on this to vet it fully, but in the interim, we have to have this TRO entered.
Thank you, Mr. Evans. So here is where I end up. This is what I struggle with in terms of the relief that is sought by Georgia Bioscience. The issue of supersedious, as I understand it, in general context, I think Mr. Russo perhaps said it, but it is intended to prevent the enforcement of a judgment while that judgment is being appealed. What has never been clear to me throughout this entire process, which has been significantly, substantially, and extensively litigated and briefed, is in this intersection between state licensing and bid awards and procedures, and the specific procedures that were, that are applicable under the HOPE Act to allow the issuance of licenses for this new heavily regulated area, is that the issuance of a license was never, as I understand it, intended, or the prohibition of an issuance of a license, or the challenging under various bid procedures of who wins a contract and who doesn't win a contract, was never intended to prohibit the state agency from carrying forward with the purpose of its existence, which was the issuance of licenses, but rather to adopt procedures to allow unsuccessful bid applicants to protest the ultimate outcome, which was the award of the contract, not whether anyone gets to provide services. So all of that is a long way of saying this. I do not believe that supersedious prohibits the Georgia Medical Cannabis Commission from undertaking to issue a provisional license. And because I don't think that, that means I have to at least touch the merits, not of the underlying argument or whether you would likelihood to succeed on those merits, but whether you've satisfied, whether Georgia Bioscience has satisfied the relative merits of a preliminary injunction in this context to restrain the Georgia Medical Cannabis Commission from undertaking those actions. And all of those things, taking into account the history of this case and the fact that the presumptive licensees have represented to the court that the contract that the Georgia Medical Cannabis Commission wishes to issue is a provisional contract. The court will not restrain the meeting from going forward at 4 p.m. to the extent that the contracts entered are the ones that have been represented to this court as being provisional and limited by the language that's been represented to and provided to this court in this hearing. To the extent that the commission seeks to undertake to do something further, the court would have concerns about that. But based on what is being represented to me, I believe that the presumptive licensees have demonstrated that there would not be a fundamental change in the status quo by the issuance of a provisional license, because the losing unsuccessful licensees would still be in a position to pursue their challenges, whether it be to the APA, if the Supreme Court grants cert, or whether it be through a certiorari provision, the ones that are still pending in front of me, or the ones that have now gone up on appeal as well. In any event, at the end of the day, I don't believe, as I said, my ruling is going to be that I don't believe that supersedious of the judgments that this court has entered were ever intended to prohibit the state agency from undertaking its statutorily required actions, number one. So I don't believe that supersedious prohibits the meeting, number one. And because it does not, I look to whether or not Georgia Bioscience has satisfied the requirements of demonstrating the risk of irreparable harm as one of the factors to consider in granting preliminary relief. And I am persuaded that there is not an issue of irreparable harm in the specific context that only a provisional license, limited in the manner and with the language that was outlined before me, is what is to be entered. And so that is going to be my ruling, which means that y'all have about 13 minutes to go forward with that hearing, and that someone should provide me, Mr. Bauer, with a proposed order that is as short and to the point as possible, so that I can get that on file for you tomorrow, so that Mr. Evans can undertake any action that he believes is necessary, understanding that the meeting that was sought to be restrained will have already occurred at that point. But at least you'll have a written order on record.
We will do so.
Anything else from the parties before you log off and go to your other phone meeting?
Nothing further, Judge. We appreciate you accommodating some very short order. Thank you.
Thank you all. And I very much appreciate the preparedness on very short notice of both sides. Thank you all very much. And I will see you